not too far away, a few streets away, in fact, is the North Gauteng High Court. And this is where the MK party is taking their bid to have these proceedings halted and stopped. Our Zoleka Qodashe is there. Zoleka, just remind our viewers what this petition is all about to have this stopped. Of course, we are in day 2, so some have said, the horse is already bolted. But nonetheless, they are pressing forward.
That's correct, Iman. You'll remember that the president in July 2025, following those bombshell allegations by KZN top cop, Lieutenant General Nhlanhla Mkhwanazi, then made an announcement that he would be making several decisions in relation to the allegations that have been leveled by the KZN Police Commissioner. One is a decision to place Minister Senzo Mchunu on leave of absence. 2 is a decision to appoint Professor Firoz Cachalia as acting police minister. And 3, it is a decision to establish the commission of inquiry that's going to be investigating these allegations of infiltration within the police service. Now, what the MK party and its leader, former President Jacob Zuma, argue is that all these decisions are essentially fruits of the same poisonous tree, in that they are irrational and illegal, and they seek that the court set aside, review and set aside those decisions. In relation to the minister, that is Senzo Mchunu, they argue that it is irrational because there is no legal provision that grants the president such a decision as to place the minister on leave of absence. They ground their argument on Section 91, subsection 2 of the Constitution, Iman, which prescribes or grants the president the powers to appoint a deputy president and ministers, assign to them their functions, as well as dismiss them. So they argue that in that provision, there is nothing that confers upon the president any power to place the minister on leave of absence. And they say that this is irrational. And you'll know, Iman, that rationality tests, although there are several tests for rationality, among them is the fact that there is a power, there is rather a legislation or law that must ground the decision of an executive or an organ of state when they exercise their public power. And so they argue that because there is no such provision, then it therefore reasons that the decision by the president is irregular and that it should be set aside. They also argue that ministerial dismissals do not amount to the same or cannot be equated to workplace dismissals, where you need to have an engagement with such an employer and grant them the opportunity to have their say. They rely on the audi alteram partem rule principle in law, which is a natural justice principle, which prescribes that parties must hear the other side. Now, they say that there is no constitutional provision or any provision that gives or burdens the president with such a responsibility where he has to hear the other side, because the Constitution, particularly that provision, only says that the president may dismiss them. Of course, it was previously argued that this may be an implied power that is granted to the president through the Constitution, but they argue the negative, that in fact it isn't even implied in the constitutional provision. But they also seek to have the hearings before the Commission of Inquiry that's currently on day 2, Iman, suspended and interdicted, because they say that that process as well is irregular. They say that the president cannot confer powers onto the Judicial Commission of Inquiry that are typically placed before the JSC, that's the Judicial Service Commission, as well as the Magistrates Commission, and that those commissions are the ones that can actually probe allegations of misconduct on the part of judicial officers. Of course, we expect that hearing before a full bench of the Gauteng High Court in Pretoria to kick off at 10 a.m. Iman.